A warm welcome to TIL Legal Speak, Episode 5. Today we are here to discuss understanding the Insolvency and Bankruptcy Code with reference to the COVID-19 crisis. For the benefit of our viewers, we are going to discuss the latest ordinance of 5th June 2020 that deals with suspension of certain provisions of the IBC code. Ma'am?
Yes, Harini. In fact, this ordinance of 5th June 2020 was much awaited. And I remember us getting so many queries from clients who are looking at the IBC code because there was no clarity. So finally, the 5th June ordinance has given us clarity, and we now know what is the way forward. So Harini, maybe we'll begin our Q&A so that our viewers can understand how the ordinance or how the COVID-19 has affected proceedings under the IBC.
Yes, ma'am, definitely. So to begin with, ma'am, could you please explain to our viewers as to what is the purpose of the Insolvency and Bankruptcy Code 2016?
Well, Harini, the Insolvency and Bankruptcy Code 2016, which is more commonly known as IBC, is a specialized legislation that has been drafted or enacted for resolving insolvency and bankruptcy issues between parties.
So, ma'am, who does this code basically apply to?
Well, this code would apply to all companies. It would apply to partnerships, both regular partnerships as well as limited liability partnerships, and also individuals who are seeking a remedy for insolvency, liquidation, voluntary winding up, or even bankruptcy.
So, ma'am, moving ahead, there's an important term that is there under the IBC code, which is default. Ma'am, could you please explain as to what default the term means under the IBC?
Well, default in simple language would mean failure to pay. It has been defined under the IBC, IBC code. As per section 312 of the IBC, default is non-payment of debt, whether in full or in part, or as an installment when the debt becomes due and payable and is not paid by the debtor. Corporate insolvency resolution process can be initiated if a default has occurred. Now, the key word over here is occur. The word occur means on the happening of the incident or event. Therefore, the event of default can be said to have taken place only if the defaulter fails to pay the debt when it has become due and payable. So one must always bear in mind that one has to satisfy the insolvency codes that a default has been committed.
So, ma'am, talking about corporate insolvency resolution process, ma'am, is there any threshold as to for filing an application under the IBC code?
Yes, Harini, there is a threshold. Earlier, the threshold for filing a proceeding under IBC was for recovery of debts of rupees 1 lakh and above. But in the recent pandemic COVID-19, this threshold has been increased by several counts, and it now stands at rupees 1 crore. So only if there is a default on dues payable for rupees 1 crore and above, then a party has the right to initiate a corporate insolvency resolution process before the insolvency courts.
So, ma'am, talking about this recovery proceedings that are initiated under the IBC, which is also better known as the CIRP process, ma'am, who can basically initiate this process under the IBC code?
Well, it could be the financial creditor, the operational creditor, or in some cases even the corporate debtor himself that can initiate a CIRP.
Talking specifically about a financial creditor, What are the circumstances under which a financial creditor can initiate a CIRP process under the IBC code?
Well, like I said, Harini, the key to filing any CIRP proceedings is always a default. So, when a financial creditor wants to file a CIRP process before the NCLT, he has to bring along with him proof of default that has occurred. Well, this would necessarily mean that the financial creditor cannot file anything which is false, frivolous, or premature for extraneous considerations. So it is only when the financial creditor satisfied the NCLT that there is a bona fide reason and a default has occurred, then and only then will his appeal be admitted in the NCLT.
So, ma'am, so far we have talked about default and dues and recovery. Ma'am, there is also another important term mentioned under IBC, which is debt. Ma'am, could you explain as to what debt means under the IBC code?
Well, yes, debt under the IBC has been defined to mean a liability or an obligation in respect of a claim which is due from any person and includes a financial debt as well as an operational debt. Debt has also been defined under the Companies Act as a definite sum owed by a person which has become payable.
Okay, so ma'am, we've talked about financial debt and operational debt in our previous question. Could you please explain a little more as to what a financial debt means under the IBC?
Certainly, Harini, financial debt has been defined under the IBC, and this is in section 5.8 of the IBC, which would mean a debt along with interest. It could be like a term loan. Financial debt also includes any receivable sold or discounted, any amount raised by credit facility, any amount raised under any other transaction such as a forward sale or purchase that has the effect of borrowing. Even a counter indemnity obligation in respect of a guarantee, an indemnity, a bond, documentary letter of credit issued by a bank or financial institution will be deemed to be a financial debt under the IBC.
Ma'am, could you also explain as to what an operational debt means under the IBC?
Yes. Operational debt under the IBC is a debt that is payable by the debtor towards goods or services and can interestingly also include employment dues that become due under an employment contract. These debts generally represent claims for money due to supply of goods or services. Under the law, an operational creditor is a person to whom an operational debt is owed and includes any person to whom such a debt has been legally assigned or transferred. Hence, even an assignee or a transferee of such right can step into the shoe of the operational creditor and make a demand for the dues.
Okay, so ma'am, as we are in a difficult crisis situation right now, which is the COVID-19 pandemic, so ma'am, according to you, has this pandemic really affected the process or proceedings under the IBC?
Certainly, Harini, it has affected IBC in 3 ways. To begin with, the threshold of filing cases under the IBC has been increased substantially from rupees 1 lakh to rupees 1 crore. The second most important aspect is that the Ordinance of 5/6/2020 has suspended sections 7, 9 and 10, which are for initiation of a corporate insolvency resolution process for any defaults, and mind you, this date is extremely important, for any defaults arising on or after 25th March 2020 for a period of 6 months, and this can be extended up to 1 year. So this period, which is the disruption period, will start on 25th of March 2020 and will end on 24th of September 2020. However, there is every chance that it can be extended for another 6 months which means that the suspension of all CIRP proceedings post 25th of March will continue till the 24th of March 2021. Having said so, Harini, I would also like to add here that the government has justified its reasonings for passing this ordinance in a twofold manner. Firstly, it says that such corporate persons who are experiencing distress in these COVID-19 times should not be pushed into a CIRP, as it would completely, disrupt their business operations. Additionally, the government also feels that if CIRP proceedings are initiated against such debtors, they will not be able to find applicants who will help them to resolve their position and come back to business as a working organization. There is another aspect that has to be taken into consideration as far as the ordinance is concerned, and that is it has added a new section 66.3. This section 66.3 says that a resolution professional cannot take any action against a director or partner of a corporate debtor on account of fraudulent trading or wrongful trading. That is, transactions which have been committed by such persons who are responsible for running the operations of the company with the intention of defrauding creditors. So in this sense also, the ordinance of 5th June 2020 is protecting these debtors.
Okay, so ma'am, thank you so much for giving us an insight into the important aspects of this ordinance of 5th June 2020. In furtherance to that, there's another section, that is 10A, that has been inserted to the IBC code by the ordinance. Ma'am, could you explain what that deals with?
Yes, section 10A of the IBC primarily is a suspension of initiation of any CIRP proceedings against companies if the default has occurred on 25th of March 2020 or thereafter. Basically, there is a suspension of filing of such CIRP proceedings so that the companies can continue in their business operations. But one would wonder that if the government is trying to protect such corporate debtors from running into difficulties because of these insolvency proceedings, what happens to small and medium enterprises that do not have sufficient money to continue their business operations and would, I would say, largely be dependent on recovering their dues from such corporate debtors? There's a big question mark on that, and only time will tell.
Okay, so ma'am, talking about the pandemic situation and the ordinance that has been passed, ma'am, what according to you could possibly be the outcome of this ordinance of 5th June 2020?
Well, the outcome would obviously mean a restriction of several very genuine cases because of these suspension of proceedings under 7, 9 and 10 of the ordinance for a period of 6 months, extendable up to 1 year. The other outcome would mean that a lot of people, a lot of companies and individuals are now out of the umbrella protection of the IBC because of the threshold. Now the threshold has gone up to rupees 1 crore. So earlier the IBC was used by people who had smaller recoveries, and it was done very successfully, and a number of them were able to come to terms, and even before the admission they would agree to pay, if not the full amount, at least part of the amount, or they would agree to pay the entire amount in a certain time frame. But with the passage of this ordinance, everything now comes to a standstill for 6 months. And if you look at the Longer period, it could be up to 1 year, which could be March 2021.
Ma'am, about that RBI moratorium.
The Ordinance of 5/6/2020 also runs parallelly to the RBI moratorium of 6 months. So as far as financial creditors are concerned, it seems it's unlikely that they would be majorly affected by defaults during this COVID-19 period. But yes, as far as operational creditors are concerned, they are certainly going to get affected.
So, ma'am, just to conclude our today's Q&A session, what according to you could possibly be the option that is left with the creditors who would want to initiate recovery proceedings against the defaults that have occurred during the COVID-19 period?
Well, in such case, they always have their remedy under the civil law, which in this case would mean filing of a suit for recovery or a summary suit. Much would depend on the facts of each case. However, of course, a civil suit would not be on a fast track. It would take a longer period of time, and there would be expenses that would include the paying of court fees and other expenses. So, well, I guess with the threshold having increased to 1 crore, most people are now left with no option but to go to the civil courts. And I think, Harini, I think with this we would have clarified all possible queries that our viewers may have. So
yes, ma'am, definitely. And if our viewers have any other further queries as well, they can contact us on any of the options that are given towards the end of this video. Thank you so much, ma'am, for being a part of today's session. And also a big thanks to our viewers to have watched us on our 5th episode of TIL Legal Speak. Thank you.
Thank you, Harini. That was very good and very quick prep work that you did. And I'm glad we were able to record this today. Namaste.
Yes, ma'am.